The United States Supreme Court on Friday handed down a victory for the digital privacy rights of individuals when it ruled that police and law enforcement agencies must get a warrant to obtain phone location data to be used as evidence in a trial. And the High Court's decision may end up having an effect on a similar case in California that is still waiting for a ruling in the Ninth Circuit Court of Appeals. In the case Carpenter v. United States, the Supreme Court wrote in its 5-4 decision that individuals should be able to expect aspects of their cell phone location data to be protected under the Fourth Amendment of the Constitution. That's the amendment that requires law enforcement and government agencies to issue a warrant prior to conducting a probable cause search of a person's property. The case dates back to a 2011 robbery in Detroit. In that case, police used 127 days of phone location data to track the movements of Timothy Carpenter without first obtaining a warrant to access his phone records. Get tech news in your inbox weekday mornings. Sign up for the free Good Morning Silicon Valley newsletter. We hold that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through CSLI, cell site location information, wrote Chief Justice John Roberts, in the court's majority opinion. Although such cell phone records are generated for commercial purposes, that distinction does not negate Carpenter's anticipation of privacy in his physical location. The court's decision overturns a ruling that had been handed down by the Sixth Circuit Court of Appeals. Andrew Crocker, staff attorney with the San Francisco-based Electronic Frontier Foundation, a nonprofit digital rights group, called the court's ruling on the Carpenter case a major victory for the privacy rights of individuals. "We're still analyzing the opinion, but the court sent a strong message by recognizing that cell phone tracking has the capability to lay private lives bare to government inspection," Crocker said. Equally as important, the court rejected the government's tired argument that sensitive data held by third parties is automatically devoid of constitutional protection. The decision doesn't seem to be a major hurdle for police and other law enforcement authorities, who can still access the data with a warrant, said Cyrus Farivar, journalist and author of a new privacy and surveillance book, Habeas Data. "This is a routine function of magistrate judges, to sign off on warrants," said Farivar. But Jim Dempsey, executive director at UC Berkeley's Center for Law and Technology, said that the ease in which authorities can obtain warrants is harder to pin. "Under our system, the warrant is the gold standard, and having to go before a judge and swear to the facts underlying your suspicion is serious and taken seriously by police and prosecutors," Dempsey said. In fact, warrants are a factor in a San Francisco case from 6 years ago that Crocker said might be affected by the Carpenter ruling. That case, United States of America v. Antonio Gilton, involves a murder from 2012 in which the San Francisco Police Department obtained search warrants for 37 days of Gilton's cell phone records as part of the department's investigation. Gilton sued on the grounds that the warrants didn't provide a substantial basis for probable cause to search his phone records. The U.S. District Court found in favor of Gilton, and the government has appealed the case to the Ninth Circuit Court of Appeals, which is headquartered in San Francisco. While the ruling could have widespread implications for the issue of digital privacy rights, Roberts said the court's decision was a narrow one. Roberts said the ruling doesn't affect other matters not before the court, or call into question conventional surveillance techniques and tools, such as security cameras, does not address other business records that might incidentally reveal location information, and does not consider other collection techniques involving foreign affairs or national security. Justice Anthony Kennedy, who has often been a swing vote on many court decisions, wrote a dissenting opinion on the ruling saying, "It places undue restrictions on the lawful and necessary enforcement powers exercised not only by the federal government, but also by law enforcement in every state and locality throughout the nation."